All right, the court is calling 2022 CR 2589W, State versus Michael Thornton. Could I have parties announced for the record?
Rick Boehner for the state of Texas.
Joseph Upheld for the defense, Michael Thornton.
And are you Mr. Thornton?
Yes, sir.
All right, so I have a motion that's from January 30th. Is that correct?
I believe so, Your Honor.
Of this year, 25?
Yes.
Yes.
All right. Mr. Thornton, did you review the motion to enter adjudication of guilt and revoke community supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney, and did you understand it?
Yes, Your Honor.
Are you the same Michael Thornton who was placed on deferred adjudication in 2022 CR 2589W for the offense of repeated violation of court order or bond condition on March 17, 2022 for a period of 3 years? Is that you?
Yes, Your Honor.
All right, state.
Violation condition number 28 on about the 11th day of December 2024 in Bexar County, Texas. The defendant, Michael Thornton, had then and there failed to attend and complete Bexar County DSCD's substance abuse intensive outpatient treatment program and violation number 28.
How do you plead to that? True or not true?
True, Your Honor.
They will waive the other violations, Your Honor.
Any objection?
No, Your Honor.
Did you understand by pleading true to violation of condition number 28, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 28?
Yes, Your Honor.
Court will find violation of condition number 28 true. Is there a proposed agreement?
There is not, Your Honor. Both state and defense are going to go before the clerk, open to our recommendations.
All right, state, what are you recommending?
State is recommending revocation, adjudication of guilt, and sentence the defendant to 3 years TDC.
All right, defense, what are you recommending?
We're recommending,
Or requesting, I should say.
we're recommending, yes, John, we're requesting from the court to follow what the PO has put in the court summary, which is to continue, extend for 3 years, continue, have Mr. Thornton into inpatient treatment. They recommend SAFE-P. There's also SATF, which is available, but SAFE-P, Mr. Thornton is ready, willing, and able to do that as well, Your Honor. If I may, on behalf of Mr. Thornton, in support of that request, Mr. Thornton has been diagnosed with PTSD as well as bipolar disorder, anxiety, depression. He has been screened and has been qualified for the BIC unit, but not DDRF. I don't understand why not DDRF, considering he has a mental health issue. He has also struggled with the use of meth and abuse of meth over the years.
Mhm.
That is what helped contribute to his issues on this probation. He has successfully completed ISF, and while he was in ISF, he was a peer educator, which got him satisfying the 150 hours of community service restitution that he was ordered to perform. What occurred this last time where he left the extensive outpatient treatment from the Bexar County was that he was staying with his cousin. Cousin got divorced. He couldn't stay there anymore. He was homeless. He ended up calling in and advising this PO that he was having a mental health crisis. In order to address that himself, he was in essence homeless. He went home to his sister's home in Wyoming, Carbon County, Wyoming, and that's where he had been. Because to him, that was his solution to take care of this. He did try to contact, and it's my information, although I haven't been able to verify it, that he was asking to transfer the case to Carbon County, Wyoming. But that did not occur, so he did go there, and that would be a violation, Judge. But he wants the court to know that he did that because he felt it was necessary, because he was homeless. And once there, he was working, and he actually been scheduled to start a job at the UP, Your Honor. He can complete this. He does have, if you add his jail time and the ISF time, 332 days of time served, but he wants help. He wants to be continued. He'd rather not have a felony conviction. This is the only felony he's been charged with. He does have 2 misdemeanors, Judge, as I'm sure you can see in his history here. So he is asking the court to extend him 3 years, place him in either SATF or SAFE-P. He will complete that. And if the court is so inclined to continue him in that manner and order those, the drug treatments, and then how he'd be supervised by MIC if he would be transferred, I'm not sure. I don't know if Carbon County has a similar supervisory unit to handle mental health individuals such as Mr. Thornton.
All right, and what place is this that he's seeking transfer to?
Carbon County, Wyoming. The city's name is Rollins, I believe it's Wlins. And his sister's name is Alicia Peterson. That's who he would be living with, Judge. And he had been employed at St. Joseph's Church as a maintenance person, but he had been hired and was scheduled to start with the UP as I previously informed the court.
All right. Probation, what is your recommendation?
Years and modified for safety. We're asking for the court summary to indicate that the term of his probation ended March 16th of this year.
All right, so I'm going to give you a choice. You only have two choices. There's not a third. All right, I can revoke you and I will sentence you to 2 years in the prison, or I will extend you for 3 years and you'll be going to safety. And then I will see if, excuse me, if Carbon County, Wyoming, I can put in the order that you to be transferred there upon completion of safety, but whether they accept you or not is completely up to the other county.
Yes, Your Honor. I'll take the second choice.
The safety, the treatment. Sir?
Yes, ma'am.
All right, the court will deny the motion and alter and amend conditions to include an extension of 3 years. He's to remain in custody for transfer to safety. And there's to be a transfer to Carbon County, Wyoming upon release from safety. Probation, are there any other conditions? All right, is there anything else you need from the court?
No, Your Honor.
All right, good luck to you.
Good luck. Thank you. Appreciate it.
Thank you, Your Honor. May I be
Thank you, Your Honor.
Yes. All right. Today's plea deadline date. Are you all going to be requesting a jury trial?
Yes, Your Honor.
All right, Ms. Ferguson, I need a jury trial date before the new year. It should be 2 days, including jury selection. All right, your jury trial date is going to be December 9th. Normally, if you'll make sure she has a reset form. All right, we're on the record in 2025 CR 008561, State versus Veronica Callahan. Could I have parties announced for the record?
Melissa Allen for the state.
Matthew Allen for Miss Callahan.
And are you Ms. Callahan?
Yes, ma'am.
All right, defense has filed a motion requesting that a bond be set. Has she not had a bond?
She had a bond set. She bonded out. She missed court, I believe 2 months ago. I had come to court to notify the court it was for a medical reason, but the court wanted Miss Callahan to come in. Well, unfortunately, she picked up other cases. I'm sure the state will talk to you about. But in addition, we did provide medical support. She also gave me the magistrate pay.
I don't need.
Okay, which shows that she continued to have that spider bite when she was picked up for the new case. Sorry, Judge. And so we're asking the court to consider a bond on her case.
All right. And what amount are you requesting?
10,000.
No, I mean-
I'm sorry. Yeah, I was gonna say, okay. We'd ask for a $10,000 bond, Your Honor.
All right, and state?
Your Honor, we're asking for 30,000. When the defendant picked up the offense that she had pending in his court right now, she was on bond for another case.
Yes.
And then after that, as he just mentioned, she picked up another case after failing to appear in court. So we're asking for 30,000.
All right, and the court will note for the record that there was a violation report. The court gave her a chance to submit to the court any medical information or to appear. She did not show. And then I believe she actually showed on October 9th, and she was on bond on October 9th.
That's correct.
And then the bondsman, I believe the bondsman asked to be off the bond, or either, I believe it's because she had picked up new cases. And what were the new cases?
She has a new possession, 1 to 4 grams, Your Honor. That case is still pending indictment. Obviously, we're waiting for the lab results. That offense date is September 3rd. I do have a copy of the offense report if the court would like to see it.
I'm not on that case, but if the court wants to consider it, I don't have an objection to the court considering that.
All right. If I can see the police report, please.
I've marked it as State's Exhibit A.
All right, any objection to State's Exhibit A for purposes of this hearing only?
No, Your Honor.
All right, then State's Exhibit A is admitted for purposes of this hearing. Thank you. All right, Ms. Callahan, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Absolutely.
All right, you can lower your hand, state your name for the record.
Veronica Callahan.
All right, in the past, have you ever had any drug issues or
Yes, ma'am.
received treatment?
Yes, ma'am.
All right, and what have you received treatment for in the past?
For, I used intravenous drugs.
All right, and have you ever had any type of mental health diagnosis?
It's been years ago. Yes, ma'am.
And what were you diagnosed with?
Manic, depression.
And I'm asking you these questions so I can figure out what type of conditions to place for you on your bond.
Yes, ma'am.
All right. All right, any further argument from either side?
No, Your Honor. Just to point out, she does have Mr. Daniel Martinez is here in her support. He's been contacting me. So I just wanted to point out she does have a support system.
All
My
right.
fiance, and he's at the Oxford House. He's got 2.5 years sobriety, and
So how long have you known him?
we've been together since 2018.
All right, so here's what I know. Sometimes when people are in their sobriety, and it seems that he's in his sobriety by being at Oxford House, you need to make sure that you're in sobriety.
Yes, ma'am.
And you cannot lean on someone who's new to sobriety to help you with your sobriety. Because if you were to use, that may take them down a path that they should not be on.
Correct. Yes, ma'am.
All right. So this is what the court will do. The court will set your bond at $12,000. The court is going to order outpatient treatment. Court will waive the fees. Counsel, you may want to see if you're able to get her into lifetime recovery.
Okay. Yes, sir.
I have Destiny. They're waiting for me at the Oxford House. Just if that's feasible for you.
I mean, yes. I mean, you need treatment.
Yes,
They'll
ma'am.
provide it. There's going to be 30 sober meetings
Yes, ma'am.
in 30 days. And I'm going to ask for a referral to Center for Healthcare Services. Is there anything else?
No, Your Honor.
All right, thank you. They'll give you a reset form, just saying.
I'm just saying.
So this is a motion to revoke. Is it going to be a contested?
I don't know yet, Judge. I'm gonna ask for the medical records from the new number one, but I don't have those yet. So
Okay.
I'd like to see those.
And are you on the number one, the new number one as well?
Yes, Judge.
All right. So then what we'll do is,
It's very, as you can see, it's the offense date of he was on probation in September of 2020.
it's over a year old.
The new number one allegedly happened in 2024, and then the MTR for some reason was just filed a year later. So I'm trying to get to the bottom of it, but I would like to see the medical records from the new number one, but I am on the new number one.
So then what we'll do is we'll set this for a contested hearing. We're going to set it in 30 days. If it's not a contested or
Okay.
if there are motions that needs to be filed, the court will hear those
Okay,
motions.
thank you.
All right. I need a 30-day reset for a contested.
November 3rd. Okay. All right.
All right, so you're going to be back here for a contested hearing on November 13th, and the court will hear whatever motions are filed.
Thank you, Judge.
Probation, is there anything else that's needed with Mr. Cantu?
You have to autograph her.
All right, once you sign the reset form, you're excused.
I hear, sir.
And Mr. Cantu, you need to make sure you're on time for court. It's 9 a.m.
Yes, ma'am.
And if there is a misdemeanor case, you need to be here first. All right?
All right, yes, ma'am.
All right, thank you. Thank you for dressing appropriately for court. We'll see you back on November 13th.
Thank you.
Meet you at the hall. There's your copy. Meet in the hall. I have the next gentleman also.
I have bad timing for some reason.
Oh, no problem. And what page is she on?
I'm sorry, but she's on page 5 down.
All right, the court is calling 2025 CR 010887, State versus Melinda Coles. Could I have parties announced for the record?
Lauren Espinoza for the state.
Dwight Chumley for Miss Coles, Your Honor.
And are you Ms. Coles?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
Ms. Coles, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
She needs to sign.
Yep. Oh,
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
sorry, Your Honor.
No problem. Ms. Coles, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, felony group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Ms. Coles, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 75 days in the Bexar County Jail under 1244 and an $800 fine. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes, Your Honor. State offers State's Exhibit 1 and all attachments.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Ms. Coles is aware of her issue with drugs. She's done a stint in rehab on her voluntarily,
And she told me that she's headed to meetings as soon as she gets out. And she has two children that are not in her custody right now, and she's working towards getting them back from CPS. And she's very motivated to stay clean.
All right. The court is finding you guilty as previously stated. The court will sentence you to 75 days in the Bear County Jail under 1244, give you credit for any time served. There's an $800 fine, time and money to run concurrently. There's to be no unsupervised contact with minors. Is this considered a judgment satisfied or no?
Yes,
All right. So does she have 75 days in?
yes.
Yes.
That's what they told us.
Okay, all right.
Yeah.
I always ask that
It's a
question.
it's always a good question to ask.
And the reason why I do that, because if you think you have 75 days in and you're saying that you have 75 days in because you're receiving 2 for 1 or 3 for 1, I'm not in charge of that. All I can tell you is for this sentence, you're going to serve 75 days.
75 real days in the trustee pod.
Well, wait a minute. You say in the trustee pod. So do you have 75 calendar days?
Yes.
Okay. All right. The court will find that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. If you're planning on getting your life together, that is fantastic, right? But with Child Protective Services cases involving children, if you have no intention of doing that, don't raise your children's hopes, and then fall through. I used to do work on that side, and there was nothing worse when I would have a child as a client and their parents, they start off doing great, coming to see them. The children are excited because they're getting ready to go home, and then they get sidetracked. Don't get sidetracked. Okay. Now, when you're released from custody, if you can't find a place, a sober living place, if I'm still here, you come back here and I'll make sure that you get help for that. And if you have a CPS attorney, stay in contact with that attorney.
Yes, ma'am.
Because if you don't, you're going to find yourself in court for jury trial over there. You understand?
Yes, ma'am.
And you only have 1 year to get it together over there.
Yes.
All right. Good luck to you. Okay.
Thanks,
Thank you
Judge.
so much.
All right. You're welcome.
That was good advice. Yeah. Be careful.
Both.
All right. Anyone else?
Yes, ma'am.
Loretta Ramos.
See?
All right. So court starts at 9. You got to be in here at 9. You understand? So if you're late, what can end up happening is a bond forfeiture can be entered. You understand?
No, I didn't hear that part.
I said, if you're late, what can end up happening is I could enter a bond forfeiture, which would mean your bond would be revoked. Your bondsman would probably be upset by that because they're on the hook for paying for it. Or either I could issue a judge's warrant and remand you without bond. You understand?
Yes, ma'am.
So in this court is at 9 a.m. Okay. All right. So we're here today. Today is plea deadline date.
It is, Judge.
And do you all want a jury trial?
Judge, we would like one reset. The basis for that is Ms. Ramos has had prior medical issues that could affect her BAC. It was a gastric bypass surgery. I'm looking into that and the ability to find an expert. But we are working through some issues with the state. We're requesting a 30-day reset. We also it's either just been filed or it'll be filed in the next 20 minutes, the standing blood discovery, because we don't have all the blood discovery, and given the medical condition and the effects on that blood, I need to look into that a little further. I think I'll be able to get that done within 30 days and probably less than that. But we're going to provide the state with some additional information, and I'm going to look for an expert.
Okay. You guys signed an acknowledgement of discovery.
Well, we hadn't filed the standing blood discovery because I was not aware of the medical condition, Your Honor.
Okay. All right,
At that time, yes, we had all the discovery that we were entitled to, but we do need the standing blood discovery because of the medical condition.
all right, Norma. Set this for a jury trial date, and your jury trial date will be the same date as your plea deadline date.
Yes, Judge.
All right, so we'll be back on December 9th.
I'll be on time.
All right, okay.
Can you give me just a moment? I just got to double check. Yes, it's perfect. Thank you.
All right, just have a seat. Once you sign the reset form, you're excused.
Thank you, Judge.
You're welcome. Who's next?
Yes.
Daryl Masters. Hello, Mr. Masters. All right, the court is calling 2022 CR 0502 State versus Daniel Masters. Could I have parties announced?
Lauren Espinoza for the state.
Andrew Fairley, Mr. Masters.
Are you Mr. Masters?
Yes, ma'am, I am.
Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, Judge, I did.
Are you the same Daniel Masters who was placed on deferred adjudication in 2022 CR 0502 for the offense of aggravated assault with a deadly weapon on April 13th,
Yes, Judge.
2022 for a period of 5 years? Is that you?
Yes, Judge, I am.
All right, state.
Yes, Your Honor. Violated condition number 2, on or about the 23rd day of May, 2025 in Bear County, Texas. The defendant, Daniel Masters, did then and there fail to submit to drug testing as directed by the supervision officer in violation of condition number 2.
How do you plead to that, true or not true?
Sure.
Violated condition number 2, on or about the 6th day of June, 2025 in Bear County, Texas. The defendant, Daniel Masters, did then and there fail to submit to drug testing as directed by the supervision officer in violation of condition number 2.
How do you plead to that, true or not true?
Violated condition number 4, in Bear County, Texas. The defendant, Daniel Masters, did then and there fail to report to the supervision officer as directed for the months of July and August 2025 in violation of condition number 4.
How do you plead to that?
State will waive the remaining.
Any objection? I'm sorry, any
No
objection?
objection, Your Honor.
Did you understand by pleading true to 2, 2, and 4, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in the prison and up to a $10,000 fine?
Yes, Judge, I do.
Knowing that, do you still wish to plead true to 2, 2, and 4?
Yes.
The court will find 2, 2, and 4 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion to revoke probation and sentence to 5 years in prison.
Is that the agreement?
It is, Your Honor.
Are you asking the court to follow that agreement?
Yes, ma'am, with times,
Yeah, and she is going to give you credit for the time that you've served, Judge. What he's asking is, will he be giving credit for the time that he was at IS?
Legally, legally, I must give you credit for any time served.
Okay.
Now, if you want credit for time in ISF, it would have to be successful completion, and probation will let me know if it was completed successfully or not.
Thank you.
All right. So are you asking me to follow that agreement?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right. So what happened? Why were you not successful?
I had major surgery, and then I had to be homeless for a while, and also it was a shaky situation with staying on my mental health medications. So just honestly, that's what happened.
Okay. And I see previously there was a MIOF evaluation. Probation, was he ever sent to safety or no?
To ISF.
Mm-hmm.
ISF successfully. Give me 1 second about, let me look at the file for state.
And if you could confirm, he was actually in Esperanza Court for a period of time, Judge?
Oh, well, he doesn't get credit for Esperanza Court.
So Judge, I do not see that he was actually, sent to state.
All right. This is what the court is going to do. The court is going to grant the motion, revoke, find you guilty. There's an affirmative finding of deadly weapon. The court will sentence you to 4 years in the prison, give you credit for any time served, credit for any time served in ISF for successful completion. There. I'm going to ask for the therapeutic community. And there's to be no unsupervised contact with minors upon release. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am, I did.
All right, we can go off the record. So let me explain to you. The reason why I did what I did is because you have completed some things since you're on probation. I know there's issues with you regarding mental health. There's issues with you regarding drugs, and based upon your acceptance into Esperanza Court, I know there are a whole host of issues that we're not equipped to handle. But here's the thing. When you're released from custody, if you go back to the things that got you in Esperanza Court, if you go back to using drugs, if you don't take care of your mental health issues, only one or two things going to end up happening. Either you're going to end up going to prison, or either you're going to end up connecting with someone who means you harm and they're going to do you harm, or either the last time you use may be the last time you use. You understand? All right. When you're released, if you need a place to stay, of course, not with me, but I will look for you for sober living. Sometimes when you tell people, hey, if you need a place to stay, I'll help you. No, I don't want anyone knocking on my door.
I apologize.
I'm not trying to be a part of the Lifetime movie. And Deputy Lawyer, you know what the title would be? Due to Kindness or something like that. I'm going to think of a name for that. And you'll say, there's no way she did that. Then the screen will go black and you'll have the Stephanie Boyd law. So we don't want a law named after me for that. Oh, I like that, because she helped, the Stephanie Boyd story. So when you're released from custody, if you can't find a sober living place and I'm here, you just come back here and I will make sure we pick up the phone and find a place for you. All right?
Yes, ma'am, thank you.
All right. Good luck for you. Zero four, State versus Roland Hernandez. Can I have parties announced?
Lauren Espinosa for the state.
Robert Mauer for defendant, Your Honor.
And are you Roland Hernandez? Counsel, in each cause number, have you received all discovery and reviewed all discovery with your client?
I have, Judge.
In each cause number, the court will find that the state is in compliance with discovery. Mr. Hernandez, in each cause number, did you review the true bill of indictments with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
I do, Judge.
State, and cause number ending in 04, are you proceeding on the indictment as presented?
Judge, for the record, Megan Galloway for the state. On the cause number ending in 04, we are waiving punishment enhancements, Your Honor.
That's understanding, Judge.
All right, off the record for a moment. All right. And then in cause number ending, so for the record, the court will note that the state is waiving any enhancements.
I apologize. This case was re-indicted, so I'm not sure if the court has the new.
No, I do not. Thank you. Thank you. So any objections to the waiver in that case?
No, Judge.
And then in the cause number ending in 03, are you proceeding on the indictment as presented?
No, Judge, we are waiving count 1 and pursuing on count 2, and then waiving the punishment enhancements, Your Honor.
No objection, Judge. That's our understanding.
All right. And State, you can have that one back.
Would that have the second?
Oh, this one's correct, yes, that I have. All right, and each cause number, did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? And the cause number ending in 04, you're charged with unlawful firearm possession by a felon. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. And cause number 03, you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea and these cause numbers will not be used against you and you will be allowed to withdraw your plea. Did you understand? And you need to speak up? And each cause number, do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering these pleas, you were giving up those rights? And did you intend to give up those rights and enter into a plea in each one of these cases? Counsel, in each cause number, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Hernandez, in each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering into these pleas, you will be deported, denied naturalization, and not allowed re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Sure.
According to the plea, the cases are to run concurrentently. Punishment is to be assessed at 10 years in the prison. There's a $2,000 fine. The state will take in consideration 2025 CR 005662. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge.
Then in each cause, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, in each cause number, do you have any evidence to support the defendant's plea?
Yes, Your Honor. State offers states of wanted attachments and.
No objections.
All right, state, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? You need to speak up.
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
We just asked the court to follow the plea bargain.
In each cause number, the court will sentence you to 10 years in the prison, give you credit for any time served. There's a $2,000 fine. Time and money will run concurrently. The cases will run concurrently. The court will take in consideration 2025 CR 005662, and there's to be no residing with minors and no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because these are plea bargaining agreements, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. You're going to have to change your life. Otherwise, you're going to end up spending the rest of your life in prison. Do you understand?
I know.
All right, good luck to you, okay?
Thank you, Judge. May I be excused?
Yes. All right, the court is going in recess.